both time and treasure, that's great. If you can do one or the other, that's good too. So thank you, everybody. So at this point, I'm going to introduce our next speaker, Norm Semanko. He's been with us now for, like she mentioned earlier, about 6 years in the fight for our water. And that's something I'm very proud of, that NWPOA has been doing, something tangible that if not for our organization and some other organizations that we're working together, and being able to pay monthly for our attorney, who is continuing to battle the tribe and the federal government. And a lot of you may not know, but the federal government basically went to the tribe and said, we'll pay for everything, and here's what you got to do to try to control the water. And so because of our great attorney, Norm Semanko, a very magnanimous attorney, we've been able to win most of the cases, but there is ongoing things that he's going to talk to you about. So Norm Semanko, come on up.
Well, good evening, everybody. It's a pleasure to be here with you again. This is always a great event, but I have to tell you, it's a little weird to me to be in this venue. And I'll give you a little background of why. So Christy shared with me before she gave that great rendition of the Battle Hymn of the Republic that she was born in San Jose, California, and so was I. My family moved here when I was 10 years old. This coming January will be 45 years that my family moved to Kootenai County. I went to Lakeland High School, and I sat right there watching Ghostbusters right there on that screen. So this is a very strange, this is the first time I've been in here since I watched Ghostbusters when I was a senior in high school. So it's a great venue though, a wonderful church. I'll have to come to service here, but it takes a little getting used to. So I have a passing interest, more than a passing interest in what's going on in Kootenai County and with this water rights adjudication. After I left Lakeland and graduated from the University of Idaho, I had the opportunity to go to Georgetown Law School and came back to Idaho. And I ended up in the desert of southern Idaho practicing water law. And I've been doing that for 28 years now. And I cut my teeth on the Snake River Basin adjudication, which is a massive basin-wide adjudication in southern Idaho involving 160,000 claims to water rights. By comparison, the Coeur d'Alene Basin, which is not a small adjudication, the Coeur d'Alene Spokane River Basin adjudication is just over 12,000 claims compared to the 160,000. Issues are very similar in terms of the involvement of the federal government. And that's what I'm going to get to here, as Jeff said, in a minute. So how many of you were born somewhere other than Idaho? Wow. And that's what I expected. And we all live in Idaho, and we all love Idaho. I wasn't born here, but I got here as quick as I could. I've heard that before. I borrowed that from somebody. And while I had a more than a passing interest, having grown up in Kootenai County, by happenstance, even though I have been trying to get back to North Idaho permanently probably for 30 years, but my career just didn't really allow that. Our daughter, Alex, who some of you have met, graduated from Bishop Kelly High School in Boise, went on to play college golf in Denver, and graduated from law school, Ave Maria Law School, a very conservative private Catholic law school in Southwest Florida, and ended up with a job in Coeur d'Alene, Idaho. And as of last month, Harper Christine Semanko Portman, our granddaughter, our first grandchild, was born here in Coeur d'Alene. So while I wasn't, and she wasn't, our daughter, our granddaughter was born here, and we have much more than a passing interest in what's going on in Coeur d'Alene and in Kootenai County. So that's just been in the last month. So let's talk about where we're at in the water rights adjudication. And just give you a little context here. The president did me a favor on Thursday by being able to help illustrate in a way that I think you all can understand. This president and the folks that, and I spent 4 years in Washington, D.C. I worked for the Republican National Committee during a presidential election. I spent 4 years on the Hill. I wrote speeches for a congressman and a senator. I understand a little bit about how that system works back there. Those words that Mr. Biden was saying on Thursday, and this is scary, were words that were written by the folks that are pulling his strings, that are operating him. That presidential election that I worked on was in 1988, when George Herbert Walker Bush beat Michael Dukakis. And who was a candidate in that race in 1988 that dropped out, disqualified himself by admitting to plagiarism and all other kinds of dishonesty? Joe Biden. And now here he is, the president, in an empty vessel, in my view, expressing the words that are on the teleprompter for him to read dutifully. What was he saying during that speech on Thursday? Yeah, it was about COVID and it was about vaccinations, but it was about so much more than that. You heard him lecture, belittle the American people. Folks who are guaranteed rights in the Constitution, who are protected, are supposed to be protected in their rights by the limited government that is the federal government. It's what our Constitution says. It's what our Declaration of Independence is about. So many years ago, the clarion call was, the British are coming. Now it's our federal government is coming. That is really what this water rights adjudication is about that. So that's part of it. The other part of it is he said, whatever I need to do, I'm going to do. We remember the pen and the phone and that president and that attack on separation of powers through the executive branch attacking the powers of the legislative branch. This president saying he's going to sweep aside the states and their governors, their legislatures, whatever he needs to do to get to regulating folks, making them do things, should send chills down everyone's spine. He's sweeping aside the concept ingrained in our Constitution of federalism, that it is a limited federal government, the powers reserved to the states and the people, far beyond the enumerated powers in Article 1, Section 8 that were set forth for the federal government. So what does that have to do with water rights? Well, water rights, as a part of property rights, that this organization has fought with the North Idaho Water Rights Alliance, Coeur d'Alene Lakeshore Property Owners Association, the Hagedon Corporation, and so many others who want to protect our property rights, our water rights here in this part of the country. The federal government doesn't control water. The states do. The states allocate those rights through a state system that's recognized through local use and custom by you, individuals, by water users, by municipal domestic users, by agricultural users, by farmers, irrigators, power producers, whatever the water use is. That's how it's recognized. The federal government doesn't have a role in that. So there is this concept in the law called Federal Reserved water rights, that when a piece of federal ground is reserved for a specific purpose, the U.S. Supreme Court decided in 1908 that federal piece of property was reserved with enough water to fulfill the purposes of that reservation. So in the case of an Indian tribe, a reservation was set aside, say in 1871, 1891, whatever it is. What was necessary for the purposes of that reservation? They need water to drink. Maybe the purpose of that reservation was to be agrarian and grow something. Those kinds of things. These things sit latent for 100+ years. These are federal rights for forest reserves. They'll assert them for wilderness areas, for any federal purpose they can think of. And this is over the settled expectations that we have from developing the land and developing the water over the last 100+ years. How do you deal with that? The federal government trying to intrude upon the states. the concept of federalism. Well, here's what's going to happen in the next several weeks. And maybe our next speaker will have an opinion on this. I think you're going to see a lot of lawsuits trying to protect states' rights, state sovereignty over what this president is trying to do. We have the unique opportunity in Idaho and throughout the West that when these water right issues come up, because of an act of Congress in the 1950s, we, the people, and the state of Idaho are allowed to sue the United States government. You can't sue the king, right? You know that. Sovereign immunity, the 11th Amendment. But the federal government, Congress, can waive that sovereign immunity, and they do for a variety of types of actions. They waived sovereign immunity, Congress did, in the McCarran Amendment, to allow states to sue the federal government and compel them to come into a state court under state rules and state laws and defend what they think they have as a water right. So that's what a water right adjudication is. When you hear that we started an adjudication, and there's one just starting up in the Sandpoint area now, the one that started here several years ago, it was a lawsuit filed by the state of Idaho in state district court compelling all claimed water users, well, we're okay because we've already been using the water, we know what we have, and the federal government. They must come into the lawsuit. So that's why you had 353 claims filed by the federal government on behalf of the Coeur d'Alene tribe, and you had what is now basically 1,000 claims filed by the United States through the Forest Service. These are asserted rights that don't, in large part, exist on the ground today. Federal Reserve water rights don't have to be used. It isn't a use it or lose it thing. They just get inserted into our system. And what's the problem with that? Why does NWPOA care? Why do the other groups care? Because if you insert new rights into a system, large rights, it can interfere with your right. All of a sudden, your water right, your settled expectation for you, your family, your community, your business is out the window. You're injured. If now water can be diverted above where you were, or you're not allowed to divert your water because it won't get down to where it needs to go for the tribal purpose or the Forest Service purpose. That's the insertion of the federal government into the state law system. So number one goal for NWPOA in this litigation was to object to all of those federal claims, and we did. The state of Idaho did as well. They've been our partners in this, as have others, like Hecla, Potlatch, some of the cities in the St. Mary's area and counties, to say that those water rights don't exist. And if they do exist, they need to be limited as much as possible because of the potential impact they can have. We want to make sure, our goal is that our property rights, our water rights, are not eviscerated, are not eliminated, are not injured. That has been our goal from the beginning. The second goal is to make sure that we don't allow for an increase in the power of the federal government, their jurisdiction and their control over our property rights, our water and our land. And that is a real issue in this case. So, fast forwarding, battling through this, summary judgment, the arguments that we've had, the Supreme Court in the state of Idaho. And yes, we're in the Supreme Court in the state of Idaho because, again, through the McCarran Amendment, we're not in a federal court. And we're not at the whims of whatever process the federal government wants to bring against us. We brought the lawsuit, the state did, and we're in a state court with state rules. And the feds have to deal with that. We get to the Idaho Supreme Court, and the federal claims take a big haircut. They've still got claims, but they're limited to the defined purposes of the reservation at the time it was created by the agreement in 1891, the legislation of Congress in 1891. The diminished reservation from what the Coeur d'Alene tribe originally had before that. So what's left now, as we won that, is to quantify the claims, to minimize their impact as much as possible. And there's two ways to do this. One is to go back to the court and run through the process. The state will take the lead. We'll be there supporting them to argue over the quantification. How much do they really need for domestic? How much do they need for agricultural? Do you really have irrigation in this area or not? How much do they need in the stream for fisheries, for hunting, fishing, gathering purposes? They didn't win commercial. They don't have a Federal Reserve water right for the golf course, the casino. They want that. They claimed that. They didn't get that. So if we go through the court process, we'll be quantifying those things. What's the risk for them? Well, they're not going to get everything they wanted. They already lost in the Supreme Court. What's the risk for us? I'm not sharing any trade secrets here. They got some water rights. Those things that I said can intrude upon our settled expectations, interfere with our rights, they got some of those. They got in-stream water rights. That can require water to stay in the stream, to not be diminished, to not be diverted, to not be consumed. That can be problematic if those in-stream rights are enforced. What do we want? We want to make sure our rights aren't injured. Well, the court can't really order that. The court will recognize the relative priorities, and here's the water rights, now state, you go administer them. But through a settlement, and that's the second course. You can go through litigation or you can go through settlement. Through a settlement, Indian claims are often, very often, compromised to allow the existing water rights that are already used on the ground, our rights, to not be impacted in exchange for something else, some other benefit. It may be a tribal settlement, might be federal funding to help build a water system for their domestic uses, whatever it might be. That's a settlement. The things you can't get out of litigation that you could get in a settlement are, number one, protecting our rights from any potential impacts from federal rights. And number two, on the federal side, they can get things other than their water rights through a settlement. Very common. A court can't order either of those things. The court's just going to decide what the federal rights are. So we got to the point in the discussions where everyone agreed, let's try to resolve this. Jeff will be the first to say this has been going on long enough. We want to get it resolved. By way of comparison, in the Snake River Basin adjudication, the Nez Perce tribes claims 1993 to 2004, 11, 12 years. It took us to get those resolved, and nobody was dilly-dallying around. It just took that long. Here we've been at it several years already. If we can get it settled, not just to get it over with, but a good settlement. One, because we won in the Supreme Court. We got the best of the battle in the Supreme Court. So we're going to have to get a deliverable in the settlement for it to make sense to us. And we've made it no secret that what we need is what's called subordination. That is that they agree, the federal government, that their rights, whatever they are, will be subordinated, inferior to ours. That no one will be injured. They'll still get their water. They'll still get to develop whatever it is they want to develop. The other thing is, what about the golf course? What about the casino? What about future commercial and industrial uses that the tribe wants? The federal government failed the tribe because they didn't win on those issues. The only way they can get those things recognized is in a settlement. So we've brought in a mediator. A mediator's been appointed. Nice man, John Thorson. Jeff and Summer were at the meeting that we had with him a couple of weeks ago in Coeur d'Alene at the resort. And we had all of our groups represented there and had a very frank discussion with him about why we're in this, what we need to protect, our property rights and our way of life for the future for our kids and our grandkids. And he gets it. He's from Montana. He came across the hill to help us do the mediation. And we're hopeful that we'll have success. The court has set a deadline in January for us to wrap up the mediation. I can't spend a lot of time talking about the details of the mediation, but I can tell you this. It's been difficult. It's been difficult. And there are discussions going on, no doubt, between the tribe and the United States about what a settlement might include. And then we've been pushing on the mediator saying, we need subordination. We've got to be protected. And we've made it very clear at every meeting, and we'll continue to make it clear. If we don't get subordination, there's nothing else for us to get in a settlement. We won in the Supreme Court. We're not afraid of quantification. We'll push those things down as much as we can. The one thing we can't get out of the court, though, is subordination, is ironclad protection of our water rights from this federal intrusion. If we get that in a settlement, we can have a very amicable discussion with the tribe. We're not there yet. We're trying. We're pushing it hard. I think we're going to get there. Almost every Indian water rights settlement in the West has included this kind of exchange of a settlement for subordination and protection of existing uses. And I think that's where we're headed. But I can't tell you for sure today. The good news is we have resolved the Forest Service claims. We won on summary judgment. The federal government did not appeal that, even to the adjudication judge, certainly not to the Supreme Court. And the settlement on that is being finalized. And basically they have agreed to subordinate, that nobody's going to be adversely impacted by Forest Service claims. And these are for things like putting out fires, for helping build roads. I mean, these are for purposes that the federal government is supposed to be using water for. So this was a fairly amicable settlement, but unfortunately there was a round of litigation that we had to go through before we got to the settlement that we have. So with that, really what this is about is protecting your property rights, using the tools that are available to us through the state court adjudication process. I appreciate the opportunity to have represented this group and the others in this battle. I'm hopeful that at this time next year we'll be reporting on a settlement. If not, we'll probably be reporting on where we're at on the quantification process with the court. But in the meantime, we are headed north now to Sandpoint. I've had a slew of meetings with folks up there. I'll be back up there again on Monday. And as soon as that adjudication started, was commenced in the Clark Fork Pend Oreille Basin by the State District Court, guess what this administration chose to do for the first time? And we've had adjudications in the Snake River Basin, the Palouse Basin, the Coeur d'Alene Spokane River Basin, and now we're just starting the Clark Fork Pend Oreille, and for the first time, the federal government has challenged the adjudication as not being consistent with the McCarran Amendment and not consistent with other provisions of law, and they've appealed the commencement order for the Sandpoint area adjudication to the Idaho Supreme Court. So now we get to deal with that challenge by the federal government. They don't want to have to participate in a state court system process, but we'll fight back. Thank you very much.